Hello friends, welcome back to my channel PU Zone. Myself Priya. We are discussing about 18 stages of civil suit and we have discussed in part 1, it is presentation of plaint, service of summons on defendant, the third one is appearance of party, and in the second part we have discussed about ex parte decree, interlocutory proceedings, written statement, production of documents and examination of parties. Now, in the third part, I am going to discuss about discovery and inspection, admission, framing of issues, summons and attendance of witnesses, hearing of suit and examination of witness. So, let's start with discovery and inspection. That is the 9th point. The purpose of discovery and inspection of document and facts is to enable the parties to ascertain the facts to be proved. With the leave of the court, the plaintiff or defendant may deliver interrogatories in writing for examination of opposite parties which are required to be answered and which are related to the matter. Now let us discuss about admission. Either party may call upon the other party to admit within 7 days from the date of service of the notice. In case of refusal or neglect to admit after such notice, the cost of proving such document shall be paid by the party so neglecting or refusing, whatever be the result of the suit may be, unless the court directs and no cost of proving any such document shall be allowed unless such notice is given, except where the omission to give the notice is, in the opinion of the court, a saving of expenses. Now let us discuss about the 11th point, that is framing of issues. The next stage is framing of issues. The job of framing of issues is exclusively assigned to a judge. Issues are framed considering provisions of Order 14 Rule 1 of Civil Procedure Code 1908. Sub-Rule 1 of Rule 1 of Order 14 of Civil Procedure Code 1908 states that issues arise when a material proposition of fact or law is affirmed by one party and denied by the other. Sub-Rule 2 of Rule 1 of Order 14 of Civil Procedure Code states that material proposition means a directly relevant or vital statement which affirms or denies a fact or of law. Material propositions are those propositions of law or fact which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. Sub-Rule 3 of Rule 1 of Order 14 of Civil Procedure Code 1908 says, each material proposition affirmed by one party, denied by another, shall form subject of distinct issue, issues of fact and issues of law. Now let us discuss about the 12th point, that is summoning and attendance of witness. On the date appointed by the court and not later than 15 days after the date on which issues are settled, parties shall present in a court a list of witnesses whom they propose to call either to give evidence or to produce documents. Now let us discuss the 13th point, that is hearing of suits and examination of witnesses. The plaintiff is entitled to have first right to begin. But if the defendant admits the fact alleged by the plaintiff and contends that either in point of law or some additional facts alleged by the defendant, the plaintiff is not entitled to any part of relief, in such case defendant has the right to begin. The plaintiff has to state his case in front of judge. The plaintiff has to submit the evidence that was earlier marked. Then the plaintiff will be cross-examined by the defendant's advocate. The witnesses from plaintiff's side also have to appear in the court, who are also cross-examined by the defendant's lawyer. The defendant also presents his side of the story supported by his witnesses and evidence from his side. The plaintiff's lawyer will cross-examine the defendant.